Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. So working on an OTR here. So you might want to know, what is an OTR? Maybe you've heard it in the scuttlebutt online, in rooms like this. OTR is on the record, meaning on the record review. By generally, we use that term in the context of being at the administrative law judge level, OHO, Office of Hearings Operations. And it would be the situation where you submit a brief. Well, technically, an OTR request doesn't have to have a brief. You can always send a letter to the judge asking him or her to perform an OTR and see if you can prevail on your claim without having to go to a hearing. In other words, you're asking for an on-the-record award. On the record meaning on the record, all your medical documents, all your statements, your function report, your work history report, and everything else. And can the judge come to a conclusion based on that without having to hear your testimony or that of a vocational expert or a medical expert, whatever the judge would think your case may otherwise need. So on the record requests are not that common. Although we do them occasionally, it seems less and less over the years. I don't know if that's just because they didn't seem to be even read, much less acknowledged. When we do an OTR, it's because we think basically that it should be a listing practically. And those are not as common as prevailing on RFC. I don't think it can ever hurt you to ask for an OTR, at least not as a layperson. I think if a representative or professional asks for one on every case, they're just going to lose all sense of credibility, because you always ask for it. Doesn't mean your case here is any more special than the other ones in terms of deserving an on the record award. So, but when we do them, we generally have a short brief that accompanies it, explaining why we think it's worthy of an OTR. I do briefs on every single one of my cases that go to hearing anyway, so it's really not too much of a problem, except that the OTR would generally, you'd want it to be done way beforehand. So it's when you're coming out of a recon, perhaps, and maybe within a few months, some additional fabulous evidence comes down the pike, you might submit it and say, hey, judge, I think this may be worthy of an OTR, and explain why with the context of the rest of the evidence also. But don't be surprised if you don't get an acknowledgement or you don't certainly get the OTR award. It is, in my opinion, by far the vast, vast, vast majority of cases the judge is going to want to have the hearing. Now, there is, of course, the option for you to not attend a hearing, and you've probably seen that option when you've appealed. I would never recommend anyone say, I want to just go on the, have you look at the records and see if you'll award me. You were denied by 2 reviews previously that were only on the record. So use this opportunity to, speak to your judge. You get your current situation down pat in terms of your current symptoms and limitations, and you get to explain why you wouldn't be able to do any job 8 hours a day from a physical or mental standpoint, or a combination of the two. Remember, even if you could do it part-time, that doesn't amount to being able to do it full-time. So if you can prove that the maximum would be part-time at best, that should be a winner also. Obviously, the devil's in the details. That's why we have all these videos out here, me and a bunch of my colleagues, with all the little intricacies that we come across and how we handle them and how, we think is best from a practical nature. But OTRs, they do have their place. I just feel like there is like a waxing and a waning of when the SSA grants them, or it just seems so, it is a rarity, but it seems like you might get a few over this past 5-year period, but not maybe in the last, like 10 years ago, maybe got a few, and then dry for like a long spell. So I don't know necessarily why that would be, but definitely it seems like a preference to see and hear the person, the claimant. I think it can add to the, and I know we're not supposed to use the word credibility factor, but I think it's something to be said about putting a face and a voice and a live person as the claimant, speaking to the judge directly instead of just that cold, hard paper, particularly when medical providers are not the best records providers. They don't articulate very well the things that are relevant to your quality of life, your ability to function in a normal, day-to-day setting. They just don't talk about that stuff. And ergo, one of the problems you have proving your case. But in any event, okay, OTRs, they have their place. You can, as a layperson, if you're self-representing, I don't see any problem with asking for one. You're probably not going to get it, but it's not like you're going to be ruining your reputation by asking for it, So, if you want to do it, do it. That's my opinion anyway. I'm sure everybody has different ones. I'll talk to you guys later. Bye. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hey there. This is in response to a request from somebody to explain a little bit about an OTR. What is an OTR? OTR is on the record, and it refers to a request one can make of the Office of Hearings Operations, where your ALJ is housed at, prior to your hearing. And apparently you could do it perhaps after a hearing, but we call those something different usually. But anyway, on the record request, you're asking the judge to take a look at the case and see if it can be determined favorably, in your favor, of course, fully favorably, based on all the medical records you've submitted, everything that's in the file as it is. Obviously, you're going to want to know what's in the file. So if you're pro se, this would mean you've had a copy of your file sent to you from the judge's office, the OHO, or you otherwise were able to get it. Sometimes they send them out in CDs, the old-fashioned way, I think. But you should be able to get it in other ways, technically, I believe. When we do an OTR, and it's not common, and the reason why I don't do them very frequently is because the judge's office, as I understand it, already does a look over to see if it is something that they can decide on the record without needing a hearing. That's the whole point about an OTR, without needing a hearing. And if they haven't come to the conclusion that it's so, and they're going to be the deciders in the end, it means they need to hear from the claimant. They're not fully convinced on the record. So the claimant has that one opportunity to show up for hearing and answer questions, and they can decide then if it changes what isn't other at all in the record very well, or it could be very close in the record and they just want to hear from the claimant. So we don't do them if it's not so clearly going to be almost like a listing. Or sometimes if something very, very major happened in the interim, and we're sending up the records, but they could have already looked at the file and, kept it going on to hearing, as most generally do. And we want to alert them to something that might very well make it into a clearly favorable. Therefore, they might be able to do the OTR, assuming I've gotten them these updated records, of course. So now they are on the record themselves. That might be one of the instances. To do an OTR, I would always put a brief and explain why I think it's an OTR. So I'm going to be putting in, referencing all of the basis upon which I think they can get to the 5 steps and find my client disabled when he or she has claimed to be. So it would be with a brief. I'm not saying that that's necessarily required, but I'll tell you that something that the SSA says right here, and I'm going to try to attach a button or here with this page so you can click right on it, because they do give a check sheet of the things that you want to cover in an OTR. Make sure that you can, explain on it's like a check sheet, that all these things, what things you think would direct them that the 5 steps have been met. And they have a link to the check sheet. So I'm going to put up this page and you can, it'll be a button up here someplace. But they say that if you believe the evidence supports a fully favorable decision, and they're speaking to us basically for your claimant, you may submit a brief to us, preferably before we hold a hearing. You may also submit a proposed check sheet. I don't see why a claimant couldn't do that, but if you're not able to articulate the connection of the legal dots and the factual dots in some kind of concise way, and when we say concise, they don't want lengthy. I mean, I hear that they want 1-page, 2-page briefs at best. This check sheet might actually be the way to go. But you could ask for an on-the-record request, and if they don't grant it, and you're probably not going to even hear if they're going to, unless they do. So if you don't hear anything, I would definitely presume you're going to hearing and plan accordingly. But an on-the-record request is certainly something that could be requested. They're not common. I think they used to be more common, but they don't seem to be of late. Maybe if, a year, it just doesn't seem that common. Granted, I take a lot of younger people sometimes, so that might not be anticipated as the strongest OTR in general, given the difficulties of that vocational profile. So we usually do tend to have to go to hearing. But anyway, I will link this page up. I don't see why a pro se person couldn't do an OTR if they wanted. Again, I would probably think it's only if you kind of know how the dots need to be connected legally. That check sheet might help you. Because if you're just saying, I want you to give me an on-the-record award because I think I'm disabled, they already know you think you're disabled because you wouldn't have applied. So you might want to give them something to reference all the little very important pieces of evidence that they should be looking at that would make it clear that the medical evidence connects the dots, okay, to the finding of disabled. All righty, OTR. I hope that helps. I don't know how often a lot of reps request them. I try to limit it to when they could be most impactful. Sometimes, and again, this is not that common, the OHO or the judge will actually issue a fully favorable on its own without you having to ask for it. And that's like an OTR. They decided to look on the record. I think I kind of alluded to this before, when they oversee everything from the beginning just to see if there's something could be banged out without a hearing. That does happen sometimes. Love it, particularly if I haven't already spent dozens of hours on a brief. I really love it. But usually I'm really, over time, I've gotten early and earlier with my briefs. I don't like doing anything close to the deadline of anything. I just don't like it. So I always have mine's being worked on all throughout the case with my client, so that it's always as close as it can be to done, but without actually being done until a few weeks before hearing. I try to get mine in 30 days ahead of time. It doesn't always happen. I have one that's got to go out next week. I think it's next week. It could be ready. I just have to finish it. Anyway, all right, guys. OTR, on the record request for an award. I'll talk to you later.